discuss with regards to a topic that is where public employment is involved. Can there be the aspect of heredity, which is, can it be accepted? Is it something which the Supreme Court can overlook? Now, why would this even be a topic of relevance? Because we already have Article 14, which ensures equality, and we have Article 16, which also talks about the fact that there will be no discrimination when it comes to matters of public employment. This is because there have been situations, especially pre independence, that certain positions, certain public positions, could have had overtones of heredity. And those overtones of heredity may have flown into post independence, that is, post the constitution came into picture. So, we are going to look into the situation of how these past principles, one may call them, are still flowing into today's times, and how is the Supreme Court responding to it. Okay, so now what happened in this particular case? The case that we are dealing with today is in regards to the appointment of a post of chowkidar. Now, this was being done on the basis of certain rules, right? These rules basically allowed for the person, the chowkidar, who was going to retire within 1 month before his retirement, prior to his retirement, to nominate an dependent or a kin of his for the post, and that would be the overtone of heredity that we are talking about. Okay, so in short, what are the facts? That in the state of Bihar, where there was a background, there was a history where village chowkidars, when they were retiring or post their death, a nomination of their family could be appointed as chowkidars. Though it was not strictly hereditary, this practice had prevailed. And now, through the rules, amendment of the rules in 2014 of the Bihar Chaukidari Cadre, there was a proviso, and this proviso again allowed for a person who was a Chaukidar to make an application for their dependent or kin to a month prior to their retirement for that particular position. Right. Now, in this situation, respondent number 7 was the son of one such chowkidar. Okay. Now, this chowkidar, after his retirement, makes an application for this respondent, his son, to be appointed as a chowkidar, resonating with this proviso. But there was one basic problem. Even if we read the rule verbatim or the proviso verbatim, it mentions that you must be making the application 1 month prior to the retirement, whereas this individual makes the application post retirement. All right, now what happens is it is rejected, the application. This respondent number 7 then approaches through a writ petition to the High Court. The High Court dismisses this because the language of the rule is clear. This same then matter goes into an intra-court appeal before a division bench of the High Court. The High Court in the division bench also upholds the dismissal. But what it does is it analyzes this proviso. It analyzes the proviso and comes to a conclusion that Article 14 and 16 have been violated, meaning this does not play along with the principle of Article 14, which is of equality, and Article 16, which requires that there is no discrimination in public employment. Both of these are contravened under the proviso, and therefore it must be struck down. So the division bench of the High Court takes this action, and which means since this particular provision or proviso itself has been struck down, implies that the respondent number 7 also does not have an opportunity for any appointment under that particular post for Chowkidar. Right. Now, this has now come before the Supreme Court with regards to one major issue. The petition is one in relation, of course, with whether the proviso, or the Supreme Court reiterates on the matter of whether this proviso does actually contravene Article 14 and 16, and provides a plethora of cases on that aspect also. And secondly, it this question is also up for understanding or clarification as to whether, when there is no challenge in the writ petition with regards of the striking down of this particular proviso, can it still be done? And can we or make a statement that the High Court had exceeded its jurisdiction by striking down the particular proviso? So we are dealing with two aspects, or the Supreme Court will clarify two aspects here. What is its stance on heredity and appointments in public offices? And secondly, with regards to, can the High Court really strike down a particular provision where no challenge has been made to it? Right. So these two questions are answered in the case. The first half, the court clarifies, and I have mentioned some of the important lines that were written in this particular judgment. First one, employment should not flow as if it were heritable. So this particular line surmises that they do not support heredity in employment, especially in public employment, in light of Article 16. They also mention a process which must be followed in case you are appointing a person, which this process they mention the publication of an advertisement, screening of the people who apply for through this advertisement, and so on. So the process basically wants to show transparency, and that the appointment to a public office must be on merit and merit alone. So the Supreme Court starts off by saying that heredity has no role in employment. Secondly, mentions a process which must be followed. And thirdly, ends with saying the fact that merit and merit alone should be the grounds for appointing an individual. It refers to a plethora of cases in order to reinstate this particular point, and highlights that this is not up for debate. This has already been answered in so many cases, and especially pointing out that it has also been answered in Bihar. Since this case is of Bihar itself, the court is saying कि हमने बिहार में भी ये क्वेश्चन को आंसर किया है, इस पे एक डिस्कशन हो चुका है, जिसमें there has been the view of the Supreme Court has been to show its disapproval towards heredity in appointment to public posts. Right. So the ground of dissent has not been appreciated if as an aspect to be taken into consideration when appointments are being made. Now we refer to the case itself. What did the Supreme Court finally say in context of heredity? It said that from these past decisions, it is consistently deprecated the practice of appointment of public service, as in public offices are heritable, and has also upheld a law which abolished village officers being appointed on hereditary basis. In short, the court is saying that we have consistently shown our disapproval towards the aspect of heredity in appointment to public service. And the court then says that we are surprised that when the Suridhar Paswan case has already taken place, why did the state of Bihar still continue to make such laws? Right? It underscored that particular aspect, that why was it still done? And it says that they believe that the division bench of the High Court rightly struck down that particular proviso. So they have given their opinion that heredity is not acceptable. It has been already concluded on multiple times through a plethora of cases, and also that the division bench was right in striking down the proviso. Now, coming to this final issue, which was that there was no challenge in the writ petition to the particular proviso, right? Now, the Supreme Court says that firstly, there is a well settled law that in matters of primary or subordinate legislation, they cannot be struck down without there being a challenge to such legislation. They accept this part that there must be a challenge. But then they mention that in this particular case, this petition, writ petition, was filed by a person who was interested in the proviso, because this proviso helped him get an appointment. So, would this person ever challenge this particular proviso? The court said it is illogical to have that expectation because he was benefiting from this proviso. So, he would never question its constitutionality, right? And the court further said that the division bench, while considering the matter of the respondent number 7, saw that the proviso was unconstitutional and therefore it proceeded to declare it void. I'm sorry. And the court said because there are so many decisions, it can be presumed that they were aware of those particular precedents that had been passed and therefore went ahead and struck down this particular provision. The court states that they don't see any reason why, when there are so many precedents present and there exists Article 141 which binds these precedents on us, and there is Article 226, why cannot the division bench of the High Court exercise its powers suo moto and strike down such a proviso? So the Supreme Court doesn't find a problem in the division bench's decision to strike down the proviso. However, it does mention that this should be practiced with care, caution, and circumspection. So, to summarize what we discussed today, the Supreme Court repeated that our stance on heredity in public appointment has always been clear since the 1960s, because we have passed decisions from that time that heredity cannot play a role in public appointments. Then, second thing, already in Bihar, there have been decisions passed on that matter. So, which further escalates the fact that the Supreme Court does not accept heredity alone as a ground for public appointment. And lastly, with regards to the matter that there was no challenge to the petition, the court said that bearing in mind Article 141 and the suo moto powers under Article 226 of the court, they were capable and they were empowered to strike down the proviso, but that this must be exercised with care, caution, and circumspection. I hope you were able to understand this case, students. I wish you a great evening.